This is going to be a short lecture about executive orders and presidential control of administrative agencies. Specifically, we're going to focus on executive orders 12291 and 12866, which are the most famous ones, and that mandated that administrative agencies engage in cost-benefit analysis when they're making new regulations. Now, a word before we get really into these two executive orders about executive orders generally. Executive orders are, the president issues a number of different types of documents directing agencies to do different things. And so these can take the form of, can be called an executive order, they could be called a memorandum. Sometimes they have other titles like a presidential proclamation or directive or something like that. There's not a clear legal distinction between these different types of presidential papers, let's say, that are issued, or even oral directives that are given from the president to his cabinet members or agency officials. On the other hand, if the document is published in the Federal Register and called an executive order, it's assigned a number. And we started numbering these in the New Deal era with FDR, because he was in office for a long time and was issuing a lot of these, more than any president before him. What they did was they went back, when they started numbering, they decided, the people coming up with the system decided it was unclear where to start in American history with this, partly because of the changes in terminology. So they started with President Lincoln, going back, and so Lincoln's executive order, first one, is numbered 1. And so by the time we get to the Reagan years, we're in the 12,000s, to sort of put it in perspective. Also, keep in mind that these executive orders, most of them are really not very exciting. They're directing agencies to collaborate with other agencies, to share information, to include other agencies in enforcement decisions, and so forth. And so a lot of them most of them you'll never really hear about. Some of them are personnel directives or directing agencies when to outsource a task and when to bring it in-house and so forth. Some of them are significant, like the two that we're going to discuss in this lecture. Generally, legally, they don't create any rights or cause of action, which means they're not judicially enforceable. And this is an important thing for law students to understand. These executive orders are not promulgated by the agencies. They're from the White House to the agencies. And so they don't really have the status of law in the sense of being something that courts can enforce. And in fact, most of these executive orders that come out of the White House under any administration are going to have a boilerplate disclaimer saying nothing in this executive order creates any rights or a cause of action in courts of law or things like that, or any private cause of action. It's also not really clear who would have standing to seek enforcement of an executive order, because it's really just the president's wishes for the agency. And so now sometimes the executive orders are challenged, which is a different legal issue than trying to compel enforcement of it. So let's say the president issues an executive order and the agency isn't really doing it. It's kind of unclear who would have standing, or how, if the thing says, the document itself says it creates no private cause of action or rights, well, why a court would allow anyone to try to enforce it, to force an agency to fulfill or implement an executive order. But it's different, though, if you're trying to seek a court order enjoining an executive order, because essentially that's really no different from seeking a declaratory action judgment or asking a court to enjoin the executive branch from enforcing a certain policy or rule or so forth. The other thing to keep in mind is that sometimes the executive orders are referenced by courts um, because they're part of the history of a regulation, and so it's not that courts aren't allowed to talk about them just because they're unenforceable. And so sometimes we'll have a regulation that the agency has promulgated, and when the regulation is challenged in court later on, part of the history is, well, the agency was told to do it or was told to do it this way by an executive order, and that's why they went the way they did. So having said that, let's go back to the two most famous executive orders by far, which are 12291 and 12866 from Clinton. Your casebook authors mostly focus on the latter one, but this really starts with Reagan's Executive Order 12291, and this was revolutionary. This was really revolutionary. And in terms of domestic agenda, this may be the most important part of Reagan's domestic agenda. President Reagan is most often remembered for his foreign policy agenda and his legacy and kind of wrapping up or standing down the Soviet Union and the Cold War and bringing the Cold War to a close and so forth. But in terms of domestic policy, 12291 was one of the biggest changes in our American legal system stateside that we've had since the New Deal. And so here's what it did. It required executive branch agencies to submit a really comprehensive cost-benefit analysis, which I talk about in another lecture, of any new proposed regulations. And agencies didn't have to do this before, and this is telling them to do it whether their enabling statute requires it or not. So if an agency wants to promulgate a new regulation, let's say it's the EPA wanting to change air pollution rules, or OSHA with workplace safety rules, before they can even put their notice of their proposed regulation in the Federal Register, they have to conduct a really extensive cost-benefit analysis. What is going to be the impact on the regulated industry in terms of costs? How many lives are going to be saved? And then there's sort of the kicker is the 12291 says agencies aren't allowed to promulgate regulations unless the benefits outweigh the costs, unless the value of the life, the number and the value of the life saved outweighs the compliance cost for the regulated industry in the aggregate. And so this was new. The Reagan administration knew this was going to be controversial and kind of kept it secret until they made it official, and until they promulgated this or published in the Federal Register. And now, where does a cost-benefit analysis go? This also matters. It goes to the Office of Management and Budget. And the Office of Management and Budget, or the OMB, which prior to this was not a very significant organ in the federal government. It was actually sort of created or reorganized and renamed under President Nixon, mostly to try to weed out duplicative or contradictory regulations. Had a little bit of updates from Carter and Ford about studying inflationary impacts and things like that. But what Reagan did was he basically in 12291 said all agencies, when they want to make a regulation, have to do a cost-benefit analysis and then have to submit it to the OMB. This means that the OMB, in some ways, is the most powerful agency that most Americans have never heard of, because it sits on top of the federal bureaucracy, sort of regulating it. If you've ever wondered, like, who regulates the regulators, the best answer to that is the OMB, or Office of Management and Budget. And so this is a smaller group of people that are, and the leader of this is handpicked by the president and works very closely with the White House and White House staff on implementing the president's policy. And so a lot of the president's policy initiatives and implementation throughout the federal bureaucracy are going to get channeled through the OMB. Now I have on this slide, the other half is the Office of Information and Regulatory Affairs. This is an office within the OMB that specifically handles the cost-benefit analyses from the agencies for their regulations, their proposed regulations. And in most of the cases, the agencies don't get it through on the first pass. The OIRA, as this is called, within the Office of Management and Budget, gets a proposal, and they come right back to the agency and say, maybe we'll approve it if you change this and this and this, because we want things to be different. We don't think that your cost benefit, that the benefits outweigh the costs enough, and so forth. So this means that this office that, again, that receives very little media attention, the confirmation hearings and things like that for OIRA and OMB are never talked about in the news, and or at least very rarely. But these officials actually have a lot of power and influence in the federal bureaucracy. And so we're going to go back for a moment to our two executive orders. So what happened is the framework that Reagan created sort of created either a watchdog or the difficult parent, sort of, for the agencies, and in some administrations, there's been a lot of tension between the federal bureaucracy and the OMB, where the agencies feel like the OMB is always, it's like going to Darth Vader to ask for permission for things, and the people at the OMB feel like the agencies act like teenagers who are always asking for more gas money or a raise in their allowance or something, that they always want to do too much, and then the OMB is there to kind of keep them in line. We have a couple of some litigation, but not very much, about the OMB from back in the Reagan era, where there was a problem that the OMB, if they really didn't like an agency like the EPA, they would just ignore their proposals. They wouldn't even say no. They would just never act on them and let months and months and months or years go by until the agency had missed statutory deadlines from Congress for promulgating new regulations. So Clinton comes into office in 1992, and one of the big questions was, okay, now we have a Democrat in the White House, maybe he'll undo 12291 and essentially rescind it, but that's not what happened. Instead, 12866 retained the basic framework that agencies have to get permission from the Office of Management and Budget, and specifically OIRA within the OMB, for new regulations that they want to propose, and they have to submit a cost-benefit analysis. There were some tweaks, though, or changes, and so we added some deadlines. And so basically, if the OMB just doesn't do anything and ignores it after a certain number of months, like 6 months, the agency can just go ahead. And this stops the abuses of the OMB just pretending that they didn't even get the request. And also there's some qualifiers, like when we look at the benefits and costs, we're not only have to look at dollars and cents, but we can also look at things like issues of equality and fairness and environmental concerns and aesthetics and things like that. So sort of the human side of things can be factored into the approval or disapproval process. And so again, we've had then, as you might expect, when the second Bush administration comes in after Clinton, the OMB again has a very robust role. People wondered when Obama took office, President Obama, if he was going to get rid of this whole framework and let the agencies kind of go back to how they were before Reagan, and that's also not what happened. And if anything, under Obama, we have an executive order that now authorizes the OMB to look retroactively, because 12291 and 12866 only apply to new proposed regulations. But in theory, now the OMB could ask an agency to make a cost-benefit justification for a regulation that was promulgated back in the 70s, and so forth. So again, the OMB and OIRA tend to kind of be out of the public spotlight. It's not the government appointment you want if you want to be famous or you like attention. On the other hand, they're very influential in terms of how the bureaucracy is going to work and what types of regulations are going to go through. That's the basics of what you need to know for now about executive orders and 12291 and 12866. If you're using my Law in a Flash flashcards, I go into a little bit more detail about it, and that could be relevant for the exams for my courses. Okay, if you need to document that you watch this lecture, our lecture attendance password is dilatory. Dilatory.